Fox NFL Sunday analyst Mark Sanchez got arrested for assault and battery, unlawfully entering a vehicle, and another misdemeanor charge after being stabbed. How does that happen? How can someone get stabbed and yet be charged with a crime? In this video, we're going to talk about that. I'm Drew Page with Tidewater Defenders. If you're new to the channel, please consider liking and subscribing. I'm going to start doing a whole lot of content now that I'm not at the Attorney General's office anymore. And the limitations on my putting videos out are now gone. I can put a lot more content again, just like I had done 2 years prior. But right now, I just want to jump into this video. So the news broke a couple days ago that Mark Sanchez was arrested after being hospitalized. They actually arrested him at the hospital. He had been stabbed in the chest and received some hospital treatment for that. And it turned out that based on police affidavits that were submitted to the court and the news reports that came out about those affidavits, that Mark Sanchez was actually the one who was the initial aggressor. The other person, there's no evidence or testimony that I'm aware of, and obviously this investigation and case is ongoing. But this person had a knife, and evidently Mark Sanchez didn't have any weapons or anything like that. So how is it that Mark Sanchez can get stabbed even though he didn't have a weapon? Well, in Virginia, which is where I'm at, we have what's called a stand your ground law. And the same is my understanding. I'm not an Indiana attorney, but my understanding based on the reports is that Indiana is a stand your ground. So it's likely that we have similar laws in that regard. So in Virginia, in the Virginia Supreme Court case of Bailey versus Commonwealth, the Virginia Supreme Court has set out clear precedent that in Virginia you do not have to retreat if you were not the initial aggressor, and you are in fear of your life. You're in fear of imminent risk of death or serious bodily injury. So if you're in fear for your life or fear of serious bodily injury, you can use lethal force to defend yourself even without retreating. But if you're the initial aggressor, then you must first retreat. So Bailey versus Commonwealth says that there are two bases for self-defense in the use of lethal force. One is justified, and the second is excused. Justified is when you're completely innocent. You were not the aggressor. You were simply going along, and you were in reasonable apprehension of death or serious bodily injury. Excusable is where you may have been at fault in starting this situation. You were an instigator of it, but you did take steps to retreat, and as a result, when you tried to get away and the other person prevented you from being able to get away, and you're again in fear of your life or serious bodily injury, you can then also use lethal force. So in general self-defense, it's all about reasonableness. So if you're feeling a reasonable apprehension of harm, then you can use self-defense. You can fight basically, but you can't use lethal force unless you are in reasonable fear of your life or serious bodily injury. So evidently the police authorities, based on the video that they saw outside the Marriott in Indiana, they feel that Mark Sanchez was the aggressor. Apparently he entered some guy's truck, according to the reports, and he wouldn't leave. The guy was trying to get him out. A fight ensued, and Mark Sanchez was the initial aggressor. And for whatever reason, this guy felt that he was in fear of his life. According to the affidavit, he told police that he was in fear of his life, which is kind of the magic word for self-defense using lethal force. So, if that's the case, then the fact that Mark Sanchez was stabbed, it doesn't mean anything. He could still be found guilty of the charges. Now, he's only facing misdemeanor charges at this point. There's 3 misdemeanor charges. I believe the other one was public intoxication. So he's got assault and battery, he's got unauthorized entry of a vehicle, and public intoxication. Those are 3 misdemeanor charges right now. What will happen? Who knows? I've tried to find the affidavit. It's not available at this time. Tried to see if there's any video out there showing the incident. Haven't seen any of that either. Evidently, ESPN and Indy USA or whatever the Indianapolis news network is, they've seen the affidavit apparently, but they haven't released it. So Once that information comes out, then we'll be able to do a deeper dive into what the likelihood of success is for Mark Sanchez. At the end of the day, with regards to the criminal case, if it's true that the guy stabbed him out of reasonable fear for his life, then he would likely not face charges. Now, in these types of assault and battery cases where it's involving a fight, a lot of times when one person is charged, the first person who's charged will then go and swear out a complaint against the other person, claiming that they were actually the instigator. And what happens is you have these conflicting warrants. And I've dealt with this a lot as a criminal defense attorney in Virginia, where I might represent one who the police took a warrant out on their behalf against what my client called the initial aggressor. And then a couple days later or whatever, that other person files a cross warrant against my client. And so there are these two competing warrants where they're both claiming that they were victims. So how does that resolve? Well, a lot of times when both sides have attorneys, the attorneys will talk and say, do you want to risk your client getting a misdemeanor conviction, or do you want to agree to plead the fifth, in which case neither person would be testifying. Now, if there are other witnesses who saw it, you can't plead the fifth. Those witnesses aren't going to plead the fifth because they're not at issue. And the police or myself or whoever the attorney is could still call those other witnesses. But if there's nobody to prosecute the case, then both cross warrants would be dismissed. A lot of times that happens, especially in the lower courts where those misdemeanor cases are argued. But sometimes if your client is like, I don't want to agree to that, I was not the initial aggressor, we can prove it, we've got the witnesses, we've got the evidence, then you put the case on, and each person has to prosecute the case. Now, private attorneys are not prosecutors. They can't prosecute the case. We can only defend the clients. So when it's their time to prosecute their warrant, they have to do the prosecuting, and then when the other side is trying to prosecute our client, then we can defend against that other person. But private attorneys are not supposed to engage in prosecution. So that's why you have Commonwealth attorneys or district attorneys, depending on what state you're in. So it'll be interesting to see how this plays out. Obviously, it's gotten a lot of national attention because of who it is, with it being Mark Sanchez, who was the number 5 pick to the Redskins back when they used to be the Redskins. And he's a Fox News analyst for Sunday Football. So it'll be interesting to see how this plays out. Obviously, there could also be a civil suit that follows behind this for assault and battery and all of that. So where a lot of times the money takes care of, sadly, the criminal part too, even though it shouldn't, and it doesn't always. But in some circumstances, when the parties are able to resolve it, they're able to reach some sort of agreement. So with that, that's pretty much it. Let me know what you think about the situation. Do you think Sanchez should be found guilty of these charges? Do you think the charges will go away and they'll just be a civil suit? And do you have any questions about this? Is your state a stand your ground state? Do you have to retreat in your state before you can use lethal force? Let me know down in the comments. Until next time, stay tuned.